This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about private limitation of action provisions and why failure to file your suit after you have a claim denied within the time limited by the policy is fatal to any lawsuit. In the Hanover Insurance Company's case against Sportsinsurance.com, each appealed from the district court's order granting in part and denying in part Hanover's motion to Sport Insurance's complaint because it failed to sue within 2 years after learning of the fact that it was the victim of an embezzlement. In Sportsinsurance.com, Inc. versus the Hanover, a United States Court of Appeals Second Circuit decision rendered on November 4, 2022, Sports Insurance claimed it discovered that Kenza El Baroudi, its chief financial officer, was embezzling from the company. Sports Insurance believed Baroudi's embezzlement constituted a loss under an insurance policy it held with Hanover, and it accordingly submitted a claim under the policy. Hanover denied the claim. Sports Insurance did not immediately sue Hanover under the policy. Instead, Sports Insurance pursued a legal action against Baroudi in Quebec, Canada. In July of 2019, the Canadian court found that Baroudi had wrongfully misappropriated money from Sports Insurance. Armed with this judgment, Sports Insurance submitted a second claim to Hanover 3 years after first discovering the loss. Hanover once again denied it. At that point, in March of 2020, Sports Insurance sued Hanover and alleged that Hanover breached both the express terms of the policy and the implied covenant of good faith and fair dealing. The district court dismissed Sports Insurance breach of contract claim as time-barred by the policy's contractual limitation provision, which required Sports Insurance to bring any action involving loss within 2 years from the date it discovered the loss. The district court found that, among other things, the implied covenant claim was not subject to the limitations provision because it did not involve loss. Creative rulings from the district court. Now, the Court of Appeal, the Second Circuit Court of Appeal, concluding it had jurisdiction to review the breach of contract claim, found that the question became whether it would exercise its discretion to do so, and concluded that Sports Insurance's cross-appeal will promote judicial and litigant efficiency without prejudicing either party. Its next issue was the question of whether the breach of contract claim was time-barred and thus subject to dismissal. Because an agreement which modifies the statute of limitations by specifying a shorter but reasonable period within which to commence an action is enforceable, language in an insurance policy's contractual limitations period is construed as starting the clock, not at the time of the accident itself, but only once the right to bring an action exists. The default rule gives way to if a policy contains exceptionally clear language that, for example, fixes the limitation period to the date of the accident. Importantly, and in relevant part, the policy defines discovered as the time when Sport Insurance first becomes aware of facts which would cause a reasonable person to assume that a loss of a type covered by the policy has been or will be incurred. That specific definition fixes the limitations provision's commencement to when Sports Insurance reasonably knew it had or would suffer a loss. This is the type of especially clear language which displaces the default rule. Therefore, the contractual limitations period commenced in January of 2016 when Sportsinsurance discovered Baroudi's frauds and thefts. The Second Circuit concluded this limitation provision is not unreasonable, nor is there nothing inherently unreasonable about a 2-year period of limitation. Sportsinsurance argued that the limitations period here is unreasonable because it requires Sportsinsurance to comply with the terms of the policy and not bring suit until 90 days after it filed its proof of loss, which it had to file within 120 days of discovering the loss. These requirements did not prevent Sportsinsurance from timely suing. Sportsinsurance discovered the loss in January of 2016. By January of 2017, Hanover had investigated and denied its claim. Sportsinsurance had a full year to bring a legal action against Hanover. It did not. Since the limitation provision is fair and reasonable, it is enforceable. In a final effort to evade the limitations provision, Sportsinsurance argued to the Second Circuit that Hanover is either stopped from enforcing or waived the limitation provision. The bare allegation that Hanover stated it was open to additional information cannot carry Sportsinsurance's estoppel or waiver arguments to forestall affirmance of the district court's order dismissing the breach of contract claim. The first 2 breaches involve Baroudi's embezzlement because the embezzlement is the basis for the claim under the policy. The implied covenant is thus time-barred. The Second Circuit accordingly reversed and dismissed the claim that Hanover breached the implied covenant of good faith and fair dealing. The declaratory judgment was dismissed as time-barred because it involves loss, as Sportsinsurance defined the term, and the trial court's creative resolution of giving some to both parties was done away with, and Sportsinsurance lost its lawsuit totally. Almost every policy of insurance contains a private limitation of action provision requiring suit to be filed against the insurer within one or two years of discovering the claim. Some states, like California, by court opinion and regulation, require that the private limitation of suit provision starts running when the claim is denied rather than when it is discovered. In this case, it didn't matter which, since the plaintiff Sportsinsurance waited more than 2 years from the denial to file suit, proving that he who sits on his rights will always lose. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on zelma.com/blog. It is also available as a video on rumble.com and youtube.com. And if you watch this video, please click on the like button or on the Rumble button as you do. And please also subscribe to the videos so you don't miss any of the now more than 550 videos available. You might also be interested in subscribing to my Locals community and my Substack publications. Thank you for your attention.